Thank you all for joining us here at Folks at the 92 NY. Yes, I've been here a long time, and I should say, with this particular evening, the cases against Donald Trump, my partner, Susan Engel, who you just heard from, she's very modest, and there's something she didn't mention, so I'll say it. It's not the kind of thing she would brag about. And that is that because everything about Donald Trump is so emotionally loaded and agitating, the 92nd Street Y, and it's just out of an abundance of caution, we have inserted, there's 5 cardiologists in the room. We don't know, they're strategically placed. If you have a shortness of breath, if you feel a pain shooting down this arm, if there's any arrhythmic problems, just raise your hand. Your health is very important. They have EKG machines and nitroglycerin pills. And you're laughing, but someone will have a heart attack tonight. Let's meet this great, and this is really, truly an insanely distinguished all-star panel and really great friends. He was once United States Attorney for the Southern District of New York, which made him the top federal prosecutor anywhere in here. He has appeared, he's been on the cover of Time magazine. He was, in many ways, famously, when Donald Trump took office, I think Preet may have been one of the longest serving US attorneys in our area, I think 9 years. Donald Trump wanted to find out, can you bend to my will? And Preet said, no, I cannot do that. And he said, well, then I would like your resignation. And then Preet said, I'm not giving it to you. And so he was then terminated. But you know, it all worked out, really, because he's now actually the fundraising chair for the Trump campaign for New York. It's amazing. He's Preet Bharara. This guy is really a true rock star. 51 argued cases before the Supreme Court. 51. I think I have this right because you were at 50 and you just did one last week. So I have it right. 51 means that he is, of minority lawyers in the United States, the one who has argued the most cases. And you know who he eclipsed? Thurgood Marshall.
Wow. Wow.
And he's so young, he's going after Cal Ripken next. He's a Georgetown Law School professor. He is an MSNBC legal contributor. I heard he was on at 12:30 this afternoon. Oh, my favorite of all, he's appeared on Billions and on House of Cards as himself. How is that even possible? He's that famous. He was himself. Neil Katyal. And this one...
Don't make me follow them.
This
Are
one,
you kidding?
This
Stop.
one, let me tell you something about this one. The hardest working person in show business, clearly. She has her show every night on CNN, the Laura Coates Live show. That's 11 till 12.
Thank you.
Where she also serves as CNN's chief legal analyst. And at 7 in the morning, another live show. She goes from 11 p.m., 7 a.m., she has a live show on Sirius Radio, the Laura Coates Show, which got a different title, very different show. I know this because I'm often on that show, and she will admit this. I can make her sing. She don't want me to do it now, but we goof around enough that I can. She actually has a lovely voice and she sings, so there's a reason. When I'm on, you get her to sing. Laura Coates.
Thank you.
All right, now I know that now they give you this grouping here, you're thinking to yourself, where's the viewpoint diversity? Where's the ideological diversity? What's up with that? And you're right about that. And there's a reason why that's the case. And I've got to be honest with you. We don't like Republicans in this building. We don't let them in the house. We tried. It just didn't work out. I once had Jeb Bush here. It didn't work out. I had Eric Cantor. It didn't work out. So, no, that's not entirely the reason, but it is partly the reason. No, one reason is that Laura will tell you this. I am emotionally neutral on this stuff. I have no ideological agenda at all. I'm very nonpartisan. I would call myself, and this is an important thing to remember, the difference between liberals and progressives. I am a classic 19th century liberal. I am open for business. You got a good idea, I'll go with that idea. I'm calm, I'm not freaking out, I'm not going to let my kids play with your kids, you know, this stuff. I'm never going to Shabbat dinner at your house ever again. How could you think something like that? I just don't do that. I don't. I'm willing to. So don't worry, I will push them. I know where the skeletons are. And there are 8.5 cases. Let me very briefly just take your scorecards out and tell you what they all are, and so then they will then make sense of them. Are you ready? There are 4 civil cases, 2 of which we probably won't talk about. Those are the defamation cases brought by the gossip columnist Jean Carroll. She ended up with 2 different judgments that totaled $85 million. Donald Trump is appealing. This is the case about how she'd written a book that he had raped her in Bergdorf Goodman's, and he then said, I never met the woman, and she's not my type. I would never touch her, and she sued for defamation. She won 2 of them for $85 million. He is now on appeal, and he took a $91 million bond. We're not going to talk about that one, in case that comes up. Let's see. The other civil cases. Let's see. What do we got? Oh, the New York civil fraud case. That one was big in the news. That's the one that had the $450 million judgment. That case originates from the allegation that Donald Trump and his adult sons artificially inflated the value of their real estate portfolios in order to get favorable loan terms and insurance contracts to the tune of a loss of tax revenue of $450 million. And so Donald Trump finally just recently got a bond for a surety for $175 million. I understand there's more argument about that. He's appealing that case also because of, among other reasons, the size of the judgment. And then the last of the civil cases is the one out of Colorado, and that's where the Colorado Supreme Court said that Donald Trump cannot appear on the Colorado ballot for the election because under the 14th Amendment, Section 3, there's a clause that says if you violate your oath of office and you engage in an insurrection, you cannot run for these various public offices. And the Colorado Supreme Court said, it's an insurrection, you violated your oath, you're out. And the Supreme Court just a few weeks ago heard argument in this case, and we're waiting to hear from the Supreme Court what they ruled. And we'll talk about what the bellwether, what the sense was among the justices. I think some of us were surprised by actually the questions that were asked. Now, there are 4 criminal cases, right? There's the one that starts next week. That's in state court. That's what's called the hush money porn star case. That's the case that essentially was 2 misdemeanors, falsification of business records. Donald Trump was paying off a porn star to make sure that she didn't disclose their affair. The fact that he made it through his lawyer and didn't indicate what it was for constitute a falsification of business records. That's why they call it that kind of a case. But it got elevated to a felony from a misdemeanor on the theory that, that he violated campaign finance laws because he was ultimately giving a contribution to his campaign. There is the 2 federal cases brought by Jack Smith, one in Washington, D.C. You still with me? With one in Washington, D.C. That one is the overturning the presidential election. It starts with the premise that Donald Trump defrauded the American people, and he also committed a different felony by obstructing what's called a federal meeting in progress. What was that meeting? The certification of the election. So that's the 2 main themes of that case in Washington, D.C., brought by Jack Smith. Jack Smith also brought one in Florida, another case. That's what's called the Mar-a-Lago documents case. Donald Trump left the White House and took with him documents both of a classified and unclassified nature, took it to Mar-a-Lago, and the argument there is that he violated by retaining, removing, and mishandling the documents. He violated the Espionage Act, and he's claiming that he has a defense called the Presidential Records Act. We will definitely explain that here today. You'll never get it better explained than you'll get it here. And that case, and by not returning the documents when it was requested, he obstructed justice. All right. The 8th case is the Georgia state case. That case is interesting because it's based literally somewhat on the case that was brought by Jack Smith in Washington, D.C. It's the overturning the election case. The difference is the D.C. case is really about Donald Trump alone. The one in Georgia under state law involves 19. It's a very sprawling case. Includes many, many different other criminal acts, including RICO Act, the Racketeering Act. Why is that important? Because if you've ever seen Godfather 2, the RICO Act explains Godfather 2. You know why I'm talking about that? Because there's that great scene in front of the Senate committee when the henchman says, I don't know Michael Corleone. I never met the guy. There are buffers between us. The RICO Act basically says if you're all committing the same crime, you don't have to all talk to each other. You don't have to plan it together. You don't have to be in communication with each other. So that it raises an interesting question because RICO is usually used as Godfather 2 for the mafia. Now there's one more, half a case. I call it 8.5 cases. There's one case that's not against Donald Trump, but it involves Donald Trump. One of the 19 defendants in Georgia has a case before the Supreme Court. And that case is about that, what I said before, the obstruction of a federal meeting in progress. And that person said, that law does not apply, it only applies to corporate malfeasance. It came out in the aftermath of the 2008 economic crisis. It has nothing to do with political rallies. You can't use a financial crime in this kind of a setting. Oh, and I forgot to mention in the other federal case, the Jack Smith, what that case has a lot to do with Donald Trump's claim, which will be argued this month in the Supreme Court, that he is immune from all criminal prosecution. That case, it originates from that case, but I guess it would apply to all of the cases. All right, that was it. That's 8.5. You ready to go? All right.
And that's all we have time for,
The
folks.
first question. Now that we got that out of the way, they don't have to explain anything about any of the cases. Now we can just get to the analysis.
You have earned your CLE already.
Here we go. Ready? Here we go. If Donald Trump, it's a foundational question. If Donald Trump had left the White House and said, the hell with all of you. I won that election. It was stolen from me. You're never going to hear from me again. I'm riding off into the Florida sunset, and I'm going to play golf, and you'll never hear from me again. Would any of these cases have been brought? Would all of them have brought? Were there some that you should have brought, but not all?
Well, one certainly would, excuse me, one certainly would not have been brought, and that's the 14th Amendment, Section 3, that you mentioned, the one relating to whether or not you should be on the ballot. I leave it to the others to talk about the other cases.
Well,
By the way,
Treat Farrar, everybody. What a mind.
I did want to express thanks to you, Thane. I've known you a long time. Thane once gave me a job, thanks very much, years ago, to be a legal writing professor at Fordham University. So I thank you for that. So the only disappointment I'm going to express is I have been led to believe that there would be 10 cardiologists.
We would need more.
Yeah.
Well, Susan, it was all her idea, Susan Engel.
Well, I'll say, I mean, first of all, it's always the head U.S. attorney who punts to the real grunt workers or the line prosecutors. It's fine. But when you look at it, you know, if you categorize it in different ways, one, there's the political response. And I think his team would tell you, but for running for office, he would never be prosecuted for anything. That this is all some political ploy to try to ensure that he will not be a viable rival of the incumbent president, Joe Biden. But I think if you look at this from the legal perspective and without that lens that he'd like to, put on you, the actions that he took to try to impede the transition of power would be things that even if he did not run for office, would still qualify for viable allegations. The behavior that he took that was outside of the realm of any official duties or acts that he was able to take as the President of the United States would still constitute criminal allegations. And of course, the civil matters that are outside of his time in the office and things that relate to claims that have been made and already resolved in some cases, I think are also there. And so you have to look at it from the perspective of, there's always the BCAD notion, there's the before the presidency, after the presidency, and what took place in between. And I think for all those areas, it's absolutely viable, but he'll have a different response.
Oh, go ahead, Neil.
Well, first of all, thank you for having me. I've not been to the 92nd Y until today. It's my first time here.
Wow.
Well, we're going to remedy that.
I've heard all about the storied institution, but learned a bit more about how the tradition goes back to 1885 and the Hebrew Association starting this, and it's a real privilege to be here, and particularly with these two. So to answer, I agree, Laura, with you. I think all of these cases would have been brought. I mean, what he did on January 6th is a crime every day of every week, whether he's going to be president or not. Again, that's absolutely the kind of thing you prosecute. Whether or not the stolen documents, I mean, before I was at the Solicitor General's office, I was National Security Advisor at the Justice Department. Of course we would prosecute this every day of every week. We would prosecute that. That's really serious stuff. And then I think the hardest one is the case going to trial next week, the so-called hush money case, which some people poo-poo is, not that serious. And, I mean, it isn't compared to some of Trump's other things. I mean, Donald Trump's legal troubles are like his hair. It's a mess. And so, yes, it's not insurrection against the government. But if you think about the entire regime of campaign finance disclosure, it's all about one central idea, which is transparency, getting information to the voters. This hush money payment occurred at a really critical time. It was days after the Access Hollywood tape had been revealed, showing Trump to be just a horrendous individual. Had the Stormy Daniels thing come out, it would have added fuel to that fire. And so he told his lawyer to go and pay the $130,000 and tried to claim it was a business expense when it wasn't, all to try and hide this from the American people and the voters. That, to me, is prosecutable, regardless of whether he's running for president or not.
Although if he was running for president, the difference is that non-disclosure agreements with porn stars are actually legal. There's nothing wrong with that. The problem is that he falsified the record. But on the other hand, he's going to say, did you want me to actually have the record notation paid off porn star? The whole point was to keep her quiet. So the question there becomes, and remember, there's also a kind of leveraging, which I would argue all the cases have a little requirement, a little gymnastics, because the cases are really, that case is really misdemeanors that got elevated to felonies because of the campaign finance laws. Now, you guys are so good at this, you're saying there's nothing wrong with that. That's what lawyers do, right? You're saying, if there's nothing wrong with saying, yes, they were misdemeanors, but they became felonies, there's nothing wrong with it. Let me just ask one other question. The gag orders, because there's one in connection with this, and we hear it in other cases. How do you feel about gag orders generally, and do you think they're necessary in this case?
Well, as long as I'm not the one being told to shut up, I love a gag order. Well, first of all, there's two things, though. Keep in mind, Stormy Daniels was also a director of her adult films as well. So she wants to be told that. She told me when she wanted that to be the key. Number two, there's the NDAs and there's the gag orders, right? As a part of an NDA, yes, you can contractually obligate yourself to not disclose information. That's fair. If you have a criminal motivation that you're trying to silence the person for, that's when you've got the transformation between what is likely to be contracted and then when you cannot contract any longer. And by the way, even if she were to agree to be silent about the NDA agreement still, if she's compelled criminally, she would still have to disclose information in a criminal setting, in a criminal court. But when it comes to the gag orders, they're so important because gag orders are intended to ensure that you've got a jury population and witnesses that are not going to be so afraid. You mentioned The Godfather. They're going to have a horse head in their bed all of a sudden because somebody is trying to keep them quiet. It's not due process. It's not fair. It's not justice. If somebody can simply intimidate you enough so that you will not participate in the prosecution of a case, because as prosecutors, your job is not to have a private client. You never set up as part of U.S. versus someone on behalf of a plaintiff. It was United States versus someone. And so you're protecting against the other population of this country who does not want to have a crime committed against them as well. And so when you stand up there, you know that you have to think about your entire jury and every witness who would be completely silenced if you do not have a viable gag order.
Yeah, I'm a big fan of the gag orders because basically of Trump's insolence and his influence. His insolence, I mean, most criminal defense, almost every criminal defendant doesn't act like a toddler in kindergartner the way he does and, call out the mob and all sorts of other things. Think about Judge Chutkan, who now has 24-hour security. She's the DC judge presiding over the Jack Smith case because of this. And indeed, credible threats against her life have happened. And then the influence, most defendants don't have the ability to call out the mob. He does. And to me, that's one of the despicable things about this individual. Leave apart the crimes. And as I say, there are many crimes. There are as many of his crimes as there are tweets, I think, from him. But a decent person facing these charges and having his supporters go out and threaten would have called them off. He never did anything like that.
But I think the complicating, and I agree with all of that, the complicating factor is that Donald Trump gets up to the line and tries to cross it. And what will be the enforcement mechanism with respect to all of these gag orders? And you don't want to have a paper tiger of a gag order. You've already seen in one of the cases where Donald Trump violated the gag order, and what was the consequence? A fine of a few $1,000s, or that could be the fine in the future if there's a violation of the gag order. Even for his depleted fortunes, it's a pittance. And the question is going to be whether or not a judge, any one of these judges where there's a gag order in place, is going to have, I don't want to say backbone, but is going to have the resolve if and when Donald Trump gets to that line and crosses over it, which I predict that he will, because that's what he does. I mean, he proudly asserted that I would happily spend a day in jail to exercise my First Amendment rights, as he calls them.
Like Nelson Mandela, apparently.
Like Nelson
He
Mandela.
feels.
So
It is going to be an interesting moment to see if a judge is going to ultimately not just fine him a certain amount and fine him more and more and more, but send him to jail for 24 or 48 hours or 72 hours because of Donald Trump's mob. And I don't like that we are in that position in this country where a judge has to worry, because a judge is a human being and judges have families, and some of these judges have 24-hour protection now. And I worry that they will hesitate to do that which they would not hesitate to do in any other garden variety case.
Okay, but none of you have said, nor would I have expected you to say, this is different because this man is running for president, and he's claiming that one of the largest issues that he's running under is the fact that the other side is trying to imprison him to stop him from returning to the White House. So that therefore, when I run for president, he says, I don't lose my First Amendment rights to engage in political advocacy. What I'm saying is trying to communicate to the American people what's happening to me. Yeah. And if you're going to gag me and keep me from campaigning, and you won't let me talk at all outside, now I understand his way of talking is not, there's no civility to that. But he is making a First Amendment argument that has been rejected several times.
But the gag orders don't say all that.
Wait. So Thane, the best evidence for why that's not true is just turn on the TV any particular moment and Trump is off blabbing about why he's innocent and why he's being targeted and everything else. As Preet's saying, the gag orders don't prevent him from that. They just prevent him from attacking judges, attacking the judge's family, the prosecutors, and the like.
No, in fact, to a lay audience, it might seem odd because these gag orders carve out his ability to say pretty much anything he wants about the prosecutor himself, about Alvin Bragg, about Jack Smith, and the Justice Department as a whole,
and the
proclaims, and the judge,
but not witnesses,
but not the staff of the judge, not the relatives of the judge, not witnesses and not jurors. So he does have a lot of leeway and a lot of ground.
Okay.
And by the way, there are people who have platforms not as big as his in this country every day of the week, who understand how to play on one side of the line. He should too.
And by the way, I mean, I always thought it was interesting that the judge chose not to include himself in it. And I think part of the reason is there has been so much ammunition that I think Trump would like to have him give over. It's like a trap to suggest if I include myself in it and I'm the judge, then I've really taken on the fact that I find this personal, right? That I'm so bothered by everything you're saying. So I might now rule in a way, Trump will say, that goes against you because I'm bothered. I think by not including himself as a part of the gag order, he's essentially saying, look, I'm taking away the ammunition from you to be able to say that I'm so biased that I'm taking this very personally. And the other aspect, of course, is, it's a fallacy to think that you really can say whatever you want without consequences. I mean, we have a whole lot of laws in this country that say, yes, you can say something, but you can't hire the hitman and not have that be a consequence, right? You can't engage in a threat. You can say it, but there's consequences to it. It's perfectly reasonable to suggest that you can campaign still without committing threatening statements or saying threatening statements in a way that undermines a chance at a fair trial or otherwise. And so I think he's trying in many ways to conflate this notion that free speech means everything from what the government can't do to what your mother tells you can't. There is actual parameters of the First Amendment that I think he's trying to capitalize on.
Was it a month ago, we were here, folks, some of you were here, and we actually talked about the First Amendment in the modern era. Let's talk about the New York civil fraud case for a second. $450 million in civil fraud. There's a few interesting things about that. This is an Upper East Side community. A lot of you live on Park Avenue. When you sell your apartments, your condos, you inflate the price. You want people to get you more money. Donald Trump's argument is to say, you know, I ended up, the argument is that he inflated the prices in order to get more favorable bank and insurance loans. But he's saying, look, I was dealing with major banks who had their own law firms and CPAs, and they did their own due diligence. I paid back the loans. The banks made money. No one's complaining other than the New York Attorney General. The New York Attorney General's job is not to protect banks per se, it's to protect individuals, consumer protection. Where is a New Yorker in any way worse off because of this? There are no victims. This is not like a Bernie Madoff situation where people are holding the bag. So there's an argument. How did you come up with $450 million other than to take away my money so I can't run for president?
So I mean, I'm the DC guy, so maybe I don't know what's going on the Upper East Side, but I know it costs like $450 million for a one-bedroom here, but I don't think that's probably what you all are doing, which is inflating your values when you're going out and getting a loan. The people who are hurt are the banks themselves, because if you claim to have X amount of dollars and as collateral for the loan and you don't have it, and you had actually X minus a million or 100 million or 200 million, then they would have charged you a higher interest rate. And so that's just, you know, and the proof of this from the New York Attorney General is the fact that at the same time as he was saying, I have these hugely inflated assets on one hand when it's coming to getting a mortgage, on the other, when it's come to paying his taxes, everything was devalued and a lot lower. And so that's the theory of the case. Those are the kinds of cases that are prosecuted all the time. And so, you know, or civilly brought all the time. And so I don't think there's anything unusual about that.
Now, there is something interesting that maybe you can speak to. That case, the $450 million civil fraud case, was originally before the Manhattan DA's office. They actually had two special prosecutors that they brought in to bring that case. They were ready to go to bring it as a criminal matter, not as a civil fraud matter, a criminal matter, and they loved the case. When Alvin Bragg took over the DA's office, he looked at the case and said, I don't like it. And instead, he brought the hush money case, right? And he could have brought this one. So I guess one question, Preet, is, you know, and oh, by the way, those two prosecutors then resigned. They quit. They were upset. They said, we've been working on this for years. We have this guy dead to rights, and you take the case away from us. So this just proves the idea of prosecutorial discretion, right? This is what guys like you do. You decide what cases to bring and what areas of the law to focus on, right?
Yeah. Just one further point to the question you asked before about what the Attorney General's job is. It's not to protect banks. I mean, I don't think of it that way. The Attorney General's job, the U.S. Attorney's job, the Attorney General of the United States' job is to uphold the rule of law.
I see.
And if you violate the law in a serious way, as Donald Trump is alleged to have done here, you bring the case. And you can't allow, when you bring garden variety cases like this all the time, both misdemeanors and felonies, against people who are not named Trump, you can't not bring the case because it is Donald Trump. So just on that point. Yeah, look, prosecutors have discretion. Civil investigators, civil enforcement authorities have discretion. And it's not machinery, it's not science, it's a little bit of art, it's justice and discretion. And two sets of prosecutors may look at a case, or look at the sets of facts, and will decide to bring the case, and one won't. Now, the distinction between the DA's office and the New York Attorney General's office on the matter that you're discussing is it's a much higher threshold to bring a criminal case, right? The standard of proof is the highest that exists in American law, proof beyond a reasonable doubt, as opposed to, which is really high, as opposed to a preponderance of the evidence, which is high, but not quite that high, provable to a unanimous jury beyond a reasonable doubt. And for reasons that we won't know when we were talking about this backstage, with respect to all sorts of decisions, other than the decision by Robert Hur not to prosecute Joe Biden, you generally don't see the memo. Is there a memo somewhere? There are probably a whole bunch of memos back and forth between those two folks you mentioned.
Explaining the decision.
And we can talk about this if you want, and they are not made public for good reason under Department of Justice policy and I think prudential policy, that if you're not going to make a decision to charge someone, you shouldn't malign them in a way that they can't
Makes sense.
defend themselves
Unless your
against.
name is Jim Comey.
Unless your name is, well, yeah. Or
soon.
or
Too
your
soon.
special counsel under particular rules, and then they become public. So, the DA's office must have decided that they can't meet that burden of proof, or they didn't like, where they were with respect to the burden of proof. And I assume it wasn't just, flipping of a coin and, you, Tish James, take this one, I, Alvin Bragg, will take this other case.
Well, can you say, though, it really annoys me to hear people talk about victimless crimes, right? You've probably heard that who's hurt by any of this? Do you know how many quote-unquote victimless crimes are prosecuted on a daily basis? You can think about somebody who purchases drugs, right? Or somebody who's engaged in a consensual, maybe it's a prostitution interaction, or any number of things where you think, well, why would you bother if no one's having an issue with it? Well, first of all, as a society, we have made decisions on the laws that we want in this country. And if society is offended, then that is an ample reason to be able to bring the case. But what really bothers me, having been a prosecutor, and I know you guys know this quite well, is that this sudden interest or a sudden epiphany that we've got maybe an inequitable system of justice in this country where it's I think it's called a two-tiered system of justice that Trump keeps speaking about. And in reality, there are issues. We have a legal system that is striving to be a just system. That's true. But the idea that if any one of you were to lie on a form for your mortgage or any bank documents, and I would be well within my rights to prosecute you, you could say, well, they didn't even take my application. They didn't even give me the loan in the long run, whatever it is. The fact that you did it is enough for somebody to be able to prosecute. And whether that's their high priority or not, very different. Okay. But that it's just the idea of Trump being angry or someone believing that, well, why me? Why me? Because then there was less opportunity to provide loans for the everyday person, because now they were tangled up for somebody else, because the law was not applied equally. That's part of what we look at in the justice system as well in terms of our discretion. And the idea that it's just now concern about, oh, well, the woe is me because I would like to be the president again, who, by the way, is the head of the executive branch of government whose job it is to abide by the law and enforce it, is just annoying.
All right. Colorado ballot disqualification case, argued recently before the Supreme Court. I think people, especially Neil for sure, but all court watchers were a little surprised because even the liberal justices seemed to be skeptical that the state of Colorado was able to invoke the 14th Amendment, one of the post-Civil War amendments that in Section 3 essentially was intended, I think I've probably said this on your show, keeping Confederate generals out of public office. That was its purpose. And the question became, A, could you apply it in this situation? Or even if you could, was it something, because there's a subsection 5 that says only Congress can do it, right? And it does seem like the Supreme Court may end up saying the real problem is, and maybe we can all address this, that you really can't do it, Colorado can't do it, but Congress can. And I will just add that I understand that Adam Schiff is saying, okay, let's hear what the Supreme Court says, and I will propose something, I don't know what he would propose, to say now Congress will essentially say you engage in an insurrection and you are disqualified from running.
So the 14th Amendment, Section 3, is not just about insurrectionists. It's not just about Confederates, it's about insurrectionists. And so the claim, which I think was 100% right, was that Donald Trump, by doing what he did on January 6th, put himself within the 14th Amendment, Section 3. And then there is another clause, Section 5, which says Congress may enforce this by appropriate legislation. And the argument was, well, Congress has to do that. They have to pass an implementing statute. So this was argued to the Supreme Court. It should have, I thought, been in a winning case. It was not argued particularly well. And so the Supreme Court unanimously rejected the challenge to Donald Trump last month in a unanimous opinion. I mean, that's where we are. There's any number of reasons why I think that's wrong, but the Supreme Court's now held it. And I think we're moving on from the 14th Amendment at this point.
I have one other question about that. So my problem with that case is that even Jack Smith didn't bring an insurrection case. Remember, that case originally was called the January 6th insurrection case. It is no longer called the January 6th insurrection case because Jack Smith chose not to bring it. Now, he could probably did that for the reasons that Preet just told us. He didn't know whether he had the evidence with a jury to show that this was an insurrection. But it does seem that Colorado is the only court out in the Rocky Mountains that has made an actual factual finding that what happened on January 6 was, in fact, an insurrection. It doesn't trouble you, Neil. You're saying, yeah, but I think it was.
It was a 5-day hearing.
Yeah.
Trump presented witnesses like Kash Patel.
No, you're talking about, I'm sorry, you're talking about the Congress.
5-day hearing in Colorado
Right.
over this, in which the judge at the end adjudicated that, yes, he was an insurrectionist. I don't think the 14th Amendment has ever required more. It certainly didn't after the Civil War. And so they're just like add-on requirements. It feels like part of a two-tiered system of justice. Oh, Congress has to pass a law to implement this? The other parts of the 14th Amendment, like the Equal Protection Clause, we've never thought are only enforceable when Congress passes a statute. They're enforceable because they're the Constitution of the United States. They're our most fundamental principles as Americans.
So you said no court other than Colorado made a determination about insurrection. Even the Supreme Court didn't base its decision 9-0, including with the progressive justices, on the. They didn't address the issue of insurrection. They didn't.
Didn't need to.
Right, because it's a procedural ground, on a procedural basis, which, you know.
But that doesn't mean that they
Not to
think
have
that
things
it was
thrown
an
immediately.
insurrection.
Right, we don't know.
Right.
Because generally on the basis that the court said that, you know, under our electoral system, our federal electoral system, if you start allowing individual states with their individual processes that vary greatly and the amount of evidence that's required, you know, to make the conclusion about a disqualification from the ballot, is it a court that's deciding, is it a commission that's deciding it? What has to be the level of evidence in each particular state, whether it's Rhode Island or California or Colorado or any other state? You kind of have bedlam. If every state on its own is making a determination of who can or cannot be on the ballot, generally speaking, for federal office, but in particular, the court found, in the case of the commander-in-chief, the president of the United States. People may not like it, but, you know, I think some of the justices saw that you could create a situation where, you know, states on a regular basis could have license to do that kind of thing, and sometimes it'll be for the guy that you like.
And you're basically making the argument that's why it's 9-0. That's really, in the end, why it's 9-0. It's not a comment about the insurrection.
Yeah, they essentially found
it's
like,
about the bedlam.
there's a lot of mischief that could be caused if we do this. And you can have the view, and I do have the view, that Donald Trump engaged in insurrection, it's just an insurrection, and that maybe that section of the 14th Amendment should cause him not to be on the ballot, but you have these other procedural issues that are important and can't be shunted to the side.
So for what it's worth, I just think that argument's weak because Preet's making a great version of it, but states all the time have different rules for who we put on presidential ballots. Right now, literally in Ohio, because the Secretary of State on Friday just warned the Biden campaign, he may not be on the general ballot because of Ohio's specific rules about who gets on the ballot and when. So that variation is part and parcel of our federalism, and it feels to me like insurrection's the hardest thing to make a mischief about. I mean, we've gone through 45 presidents. No one else has been accused of insurrection except one guy.
You know, though, I think that people are not perhaps as committed to this, even in spite of the weight behind the legal arguments. I think there is a real, genuine fear in the court of public opinion, if not in the court of law, that taking him off creates an opportunity to make him a political martyr. That there is the thought that people would like to best you at the ballot box. And I think there were so many people who thought to themselves, okay, the law might be right. Absolutely, he should be off the ballot, but if you take him off the ballot, then it creates an opportunity for him to say, look, this is yet another example, and they want to beat him, quote unquote, fair and square, even though that happened once, but something happened after. What was it? What was it?
So let's move on to the, because we're talking about the Supreme Court. Let's move on to the Washington, D.C. case. That's the one of the two cases that deal with the overturning of the election. That case is on hold right now, and the Supreme Court is going to be hearing an argument later this month on Donald Trump's argument, which basically, if he were to prevail in front of the Supreme Court, would pretty much put an end to all of these cases, with the exception, I guess, of the obstruction of justice in Mar-a-Lago. Seems to me the only one that would survive is that after you left the presidency, you were still messing around and you don't get presidential protection. Donald Trump is going, he's saying, look, I have a presidential immunity. Everything that I did before January 6th and after January 6th was within the scope of my duties because half the country thought this election had been stolen, and I was trying to get to the bottom of things. Yeah, I understand I had a self-interest, but it's my job, and I went ahead and did my job, and so therefore I'm immune from prosecution. The Supreme Court's going to hear that argument. Watch Neil's face. He's cardiologist.
Exactly.
All right. That argument, I don't know where you think that's going to go with this court, but
So, I've taught constitutional law 20 times. For the first at least 16 or 17 before Trump, I would teach the immunity cases with Richard Nixon's famous line in the Robert Frost interview, when the president does it, it's not illegal, which everyone, I don't care where you sat on the political spectrum, thought was insane. We now literally have a Supreme Court case about whether that theory is right or not. It cannot be right. Yes, presidents get all sorts of perks and former presidents. They get Secret Service protection and a lifetime pension and the like, but you don't get an absolute immunity, free out of jail card as a result of serving as the president. And the best person to have explained that was a lawyer for a guy named Donald Trump, who in January of 2021, after he lost the election and was being impeached, he sent his lawyer out to say, don't impeach him because after he leaves office, you can indict him. And that has always been the law. The Justice Department has two different memos from 1973 and 1999 that say you can't criminally indict a sitting president because of the interference with executive functions, but the moment they leave office, of course you can. That's always been the law. It's going to be the law. There's no chance that Trump prevails in the Supreme Court.
Can I ask Neil a question? What's the vote going to be?
I think it'll be unanimous.
It'll be 9-0.
Yeah.
Wow.
I mean, in the same way as Nixon versus United States, when Nixon had appointed 4 of the justices, 3 of them sat on the case. Everyone thought, oh, they're going to do his bidding. They didn't do his bidding. And if you think about, for example, the executive privilege case, which my nonprofit did just last year, in which Trump claimed executive privilege against the January 6th committee, that was an 8-1 decision with only Justice Thomas saying Trump might have a claim about executive privilege. All other 8, including Kavanaugh and Gorsuch, who were his appointees, voted against Donald Trump.
Is there a world that he could, I wonder, is there a world that they're going to argue it or going to decide it about the parameters of was it an official act as opposed to just the straight immunity question?
good question.
Because of course, this is all about, in part, he's claiming that these are all official presidential acts and that the rest of us don't get how politics work. This is always what the president would do.
Last I checked, insurrection's not part of the official job description.
I'm with you. But will these
scope.
justices think that? Will they argue it or think about it in that way at all, you think?
I don't think so. But I mean, that's the best version of it. That's what Trump's brief is trying to argue. I think it dissolves pretty quickly, and I think it'll be a really fun argument to watch. I suspect Jack Smith is going to have Michael Dreeben, the legendary former Deputy Solicitor General, argue the case. He's working on the team, who's phenomenal.
All right, let's get to the Mar-a-Lago case. This one is fascinating on many levels. One level is that came up last week, this Presidential Records Act. If you watch some networks, you hear it never. You hear Southern X, you hear all the time. So the Presidential Records Act, the idea here is that if I'm a president, George Washington did, so can I, take stuff home. Now after Watergate, they passed this law, the Presidential Records Act, presumably with the idea saying, Mr. President, we understand you have keepsakes and you have sentimental things, but the stuff really belongs to the American people. It really doesn't belong to you, but we can discuss with you some things like this menu from a White House dinner. You can take that, right? So he's saying, well, I was still negotiating, and I have a right to have access to this law. You instead have called me an enemy of the state. You're treating me like Julian Assange and Chelsea Manning and the Rosenbergs and Edward Snowden and Jonathan Pollard. I'm not them. I have a possessory interest in holding it. And none of these people did. And you're going to put me in jail for holding it? I didn't sell it to the North Koreans. I didn't give it to the Iranians. I'm just a child, and I moved it to my sock drawer and I didn't want to give it back. Everything everyone's undisciplined, reckless. I'm all those things, and I proved it with the Mar-a-Lago sock drawer. I just didn't want to give it back, and I moved it into the kitchen. So I just want to understand, did you all really think that the Espionage Act is the, Neil is yes, the Espionage Act is the appropriate crime here?
Yeah. I mean, look, duh. Look, part of the problem with some of these things is people take the name of the act, and the act has provisions in it that don't relate to what we think of when we watch the movies, when we think about the Rosenbergs as espionage.
You mean like Boris and Natasha?
Exactly.
Right,
they were criminals.
spy.
Right, so you see partisans who are in support of Trump talk about how he's overcharged because the name of the statute overall has many, many provisions, some of which violations of are very, very serious, some less serious. Some go exactly to what we think of classically when we think of espionage, and some go to things that are also very, very important, like the willful retention, once you're a private citizen, have no need to know, don't have a security clearance, of documents that were created by the intelligence community, not a menu from the mess hall at the White House, that would have severe consequences if they became known to our adversaries and others alike. That's in the Espionage Act, and has nothing to do with the Presidential Records Act. So I don't know what the complaining is about, because to me, of all the cases we've been talking about, the clearest, smoothest, most streamlined prosecution is this case under the Espionage Act.
No, but I'm saying the Espionage Act or the Obstruction of Justice Act. The sock drawer issue is really obstruction of justice. That's when the government said, give it back, and I went, I already did. And then he put it in the sock drawer. That's obstruction of justice. To me, that was so obvious he should be prosecuted. There's nothing more closer to that. But the Espionage Act...
But they're connected to each other, right? So my view is that if Donald Trump hadn't obstructed, he would have been charged with the Espionage Act either. Right?
What if he had?
He would not have been charged under the Espionage Act either. It was the plus factor, the aggravating factor.
Oh, wow.
That again and again and again. Look.
You're saying that it's the obstruction that led to the espionage charge?
Yeah, I think 100%.
Wow.
Right?
Yeah.
Look.
Robert Hur said something similar.
Yeah.
That was the entire premise of the special counsel's report, right? That where the two's behavior diverged was once you were told to return it, right? And I think people have to understand the reason you've got this willful retention. First of all, you said he didn't hand it over. I don't know what he did with the documents yet. I have no idea. I'm a skeptical person in general. I have no information.
You're saying it might be with the North Koreans?
My point is I don't know what it is. And also I'm of a photocopy generation where you could, I mean, this part of me is like, so do you have everything? I mean, did you photocopy it? I don't know what's going on. But there's also an idea that you can't, with documents that you describe, no one should be trusted with it following their ability to have it. And so you prosecute on behalf of that particular, under that statute, because you cannot trust that somebody has pure intentions with intentionally maintaining the document when they no longer have a lawful right to do so. Forget the trust but verify. Don't trust and prosecute when it comes to things of national importance.
Yeah, so I mean, there's two parts of this. One is the classified information part, of which I think, to put Preet's point most concretely, people give their lives for this kind of information. I mean, this is sources and methods in the most extreme way. Of course the government has to protect it. Of course it can't be that Biden, when he leaves office, gets to take it all home with him and put it in his golf club. No chance. That's one thing. And then the other is, once Trump was asked for it, he didn't give it back. So it's like, and Trump says, oh, it's like what Biden did. No, it's like, imagine you go and you borrow, there's two people who borrow books from the library. Both refuse to give them back. One discovers it 2 years later and gives it back, walks in and says, I'm so sorry, it's overdue, and so on. That's very different than the person who's asked to give it back, says, oh, I don't have it, and then sends his people around to move the book from one place to another and hide it and the like, which is what Trump is accused of doing.
But there is one more piece to this, Neil, which is that there are only 4 people on the planet that the Presidential Records Act applies to, and he's one of them. And you know who's not one of them? Joe Biden.
Yeah, it just doesn't matter for this thing. I mean, the Presidential Records Act defense is, I think the legal technical term is garbage. I mean, nobody in their right mind would entertain this as a serious
argument. Is that why Jack Smith last week was jumping up and down to say
it's a civil statute to govern how presidents should think about their records when they leave office. It's not some sort of get out of jail free card for you to bring home classified information. The whole intent of the act was the opposite. It was after Nixon was taking stuff home that they wanted to provide some streamlined procedure over it.
There was another aspect of this also. As a legal matter, Neil is absolutely correct. The Presidential Records Act, the PRA, has nothing to do with any of this. Also, as a factual evidentiary matter, it's all made up, right? Jack Smith has argued that this whole idea of a defense based on the PRA is something that was not considered before he took the documents. He didn't tell to anybody. Every witness they interviewed said, we never heard the PRA being invoked in this context at all. It's all made up, to go into
After the fact.
After the fact, by a guy who's not a lawyer who whispered into Trump and Trump's lawyers' ears that you should assert the PRA. So there's a legal justification for it. But even if there was a good faith mistake of law, that doesn't exist either, because this is all made up after the fact.
All right, let's get to the Georgia case. God, we covered all of them, actually. The only one I want to make sure we get Neil on that, the 8.5 one, the one about the obstruction of a federal meeting in progress, because that's coming before the Supreme Court. But before we do that, I want to talk about the Georgia case for a second. The first question is, RICO statute, clever idea, makes sense, should be used, distorts the meaning of what RICO was intended for. And the second question is, do you think that Fani Willis, given the whole scandal, that she should have simply said, you know what, I got to step away, and maybe we should find another district attorney in this state. Now remember, that's a problem, because Georgia is sort of a purple state, right? Some of those DAs would want this case. She wanted this case. So I'm wondering, do you think that her holding back and saying, the only one who's going to win it is me. No one else will take it. No one's ready for it. I want to stick with it, even if it looks bad.
I think it was certainly an unforced error to provide ammunition to anyone of a matter of this consequence, period. However, they didn't meet the burden of proving that she should be disqualified, and she's on this case. And it's not as simple as simply saying, I'd like you now to handle it. In Georgia, it would go to a prosecuting counsel who then would decide who would take up the case. If there's no volunteers, and guess what? There'll be no volunteers. Then it could be assigned to somebody, which means that they don't have to be beholden to the grand jury decisions they've already had, to any of the decisions that they've made in the DA's office at all. It would effectively either slow walk or stall it indefinitely if it's ever brought at all. But at the end of the day, the same demand that the burden of proof be met as a criminal prosecutor has to be met in a different way with the disqualification. You had to prove there was a conflict of interest sufficient to mean that they could not have a fair trial. Now, I don't know whether Fani Willis truly keeps cash everywhere she says she keeps cash, or whether they went Dutch every time she says they went Dutch. What I do know is that that has little to nothing, if at all, bearing on the ability of a defendant to get a fair trial. What they're trying to suggest is that they were maintaining their relationship, whether it was sexual or otherwise, because they wanted to be together longer. So here's a way, not a movie date, not a Netflix and chill, but let's have a 19 or 18 co-defendant case involving the former presidents. We can take a road trip maybe one day to West Virginia. That's what they were arguing was the case here. Now, I have been married a while. I don't know how the young people date any longer. But that's not enough. That's not enough. And so they failed. She's on the case, deal with it.
That was great.
And by the way, a lot of the people who are making the argument that it's outrageous that she's not recused or that this decision came down are in the same group of people who think that Clarence Thomas should not recuse himself when Ginny Thomas was involved in the way she's been involved in all the ways that you all are hissing about. I appreciate the hissing.
That was a trigger just now. Everyone's, ooh, Jeannie, ooh.
I mean, the other thing about the Georgia thing, though, is that I just wonder, first of all, the whole thing feels like a crossover episode of Law and Order meets Days of Our Lives. But
I was here for all of it.
But, even before the disqualification came out, there wasn't ever a date set. And that's always puzzled me. I don't know if you all have a thought on that, but I would think that would have been one of the first things that they would have been pushing for, and they just never did.
The date from the
trial.
For the trial.
Yeah.
Yeah, she thinks it can happen this summer still. She's thinking, Fani Willis, that by August. I think that's
not
it's a fool's errand to think of. A pipe dream. But I do think, I'm always so fascinated. We just to circle back. there was so much criticism about the audacity of Alvin Bragg to go first, quote unquote. And now in the end, he will go first.
Yeah.
He might be the
He may
only
be the only one.
He may
Right,
be
the only one.
Right. All right, we're going to get questions from the audience, but I have that last question I want. And, well, by the way, for CLE credit, I always forget. If you're getting CLE credit, the code to start the system was XRT564, XRT564. And at the end of tonight, the way you get your credit is NPL489, NPL489. Okay, I want to get back to this, what I call the 8.5 case, because I think that one is so huge, and it's a sleeper case, because it could end the whole thing. Now, the question there is, there's 900 people that are in jail for January 6th, and most of them are in jail not for seditious conspiracy, not for insurrection, but for this thing, that they interfered with the counting of the votes, that they obstructed justice, or in this case, a specific law of obstructing an official meeting while it's in progress. This law became the linchpin that put all these people in jail. Now, one of the people that bringing the Trump defendants, one of the 19, is saying, you can't use that law against me. That law applies to corporations. It's a post-2008 recession law. It's about corporate malfeasance. It has nothing to do with political rallies and people going crazy. And I'm not responsible for that. It's a whole nother law. If the Supreme Court ultimately rules that this is a Wall Street crime and not a, Washington, D.C. crime, then it just seems to me not only does it knock out a major theme of the Mar-a-Lago, the Washington, D.C. case, the Washington, D.C. case for Donald Trump, but it might in fact knock out the same thing for all of the other people that were imprisoned.
So it may at the federal level. The state prosecutions are totally different under different statutes. Right. I think it's a hard argument for the defendants. Judge Carl Nichols is a very good judge on the trial court who did side with Trump and the Trumpistas on this. But basically, because the statute is written to say obstruction of an official proceeding, and that's the plain text, yes, it was passed as part of Sarbanes-Oxley after a series of corporate scandals and reforms, but the text is the text. And last time I checked, I thought it was conservatives who said we focus on the plain text of statutes and not the legislative intent or trying to divine what their purpose is. And so Trump and his allies are making a kind of legislative purpose argument, which is what the Supreme Court was known for in the 1970s. It's not today's Supreme Court, so I think it's going to put them in a difficult position.
All right.
But I don't think it's all, I don't know what the percentage is, but of all the January 6th defendants.
No, I think you're right, not all.
It's some subset of them.
Well, there's like the destruction of federal property. There's all kinds of things, attacking a policeman. There are all sorts of things, but it does seem like that.
But I think it's a big deal. I'm glad you talked about it. It's a big deal thing that's hanging in the balance and will affect the Trump case as well.
Yeah, it will definitely affect the Trump case in the D.C. All right, some
Sounds
questions?
like a bunch of patriots who should be pardoned.
They're hostages, Neil.
I think he's joking. All right, can you all comment? I love this question. Can you all comment on the impact of all of these cases on how the legal system is perceived by the general public? It's one thing for us, we're inside baseball. Yeah. But if you're not inside baseball, not everyone here, we have a lot of civilians here, you're saying, yeah, but it just doesn't look good. It looks like you're attacking your political enemies. It looks like you're giving Trump the high ground by proving to him that you won't let him campaign.
I think it makes people believe that the rich get away with anything. Mm-hmm. I think it's not about. I don't think. First of all, Biden's DOJ is not responsible for prosecuting the state crimes at all, and there's also. You can't very well think that Hur's decision had Biden's hand all over it, let alone Jack Smith. I do think people are frustrated with the notion of a quote-unquote Teflon Don, but it's not just him who is Teflon. It's anyone who's able, we're talking a lot about delay and the delay as a tactic. Every defense attorney has the right to be as zealous as they need to be for their client, even if it includes delaying, hoping for a different result. And I think that what people are seeing firsthand now in front of their eyes is that this is far more common to be able to navigate and manipulate the legal system to your will, provided you have the funds and unlimited resources to do so. And I think that's what people see about the system right now, more than politics.
To me, it's like I don't know what, the question is a difficult and complicated one because I don't know whose perceptions we're talking about. The perceptions of the people in this room is one thing. The perceptions of the people who are supportive of Donald Trump is quite a different thing. And so if you're in the position that you think that the Donald Trump, the grievance monster is correct and he's being persecuted, then every additional case causes you to retrench and believe that further. I mean, the data all shows that that Trump was fading as a political figure within the Republican Party. That's why all these people jumped in. And his political fortunes rebounded, beginning with a particular inflection point, the point at which Alvin Bragg decided to charge him, which goes against all the laws of political gravity, heretofore, right? So people are very polarized. They believe in their candidate, and people are very hard to persuade otherwise. No matter how brilliant we are in talking about the law and talking about the rule of law and talking about these cases, there's a perception on the part of not a small number of people, but tens and tens of millions of people. I don't have an answer to how you solve this dilemma. Tens and tens of millions of people, their reaction to these cases being brought is to trust prosecutors less, trust the Justice Department less, trust the courts less.
So that to me, though, is why it's so important the cases occur and actually go forward, because Laura's point about how there's a fear that there's two tiers of justice and the rich get one set of justice, and Preet's fear, which is that the Trump folks will think this process is inherently unfair with every indictment. I mean, if you think about it the way our founders did, they said, hey, that's exactly why we architected the system we architected, which is prosecutors on their own say-so can't indict someone. You got to get a grand jury to sign off on it. Then there's a criminal trial in which you have the highest burden of proof, as Preet said earlier, imaginable, beyond a reasonable doubt, the highest standard in the law. All 12 jurors have to agree. It has to be unanimous in order to convict someone. You're going to have the right to counsel, including expensive defense counsel that Trump has. I mean, Trump has so many lawyers at this point. I think they're forming their own branch of government or something. But you've got all of these different protections plus the other things in the Bill of Rights. And to me, it's like, let that process unfold. Trump's so scared to let the process happen. But he has every advantage in that process. If you let it unfold, I do think, show that to the American people. I think that's the way to actually reduce the fear about people being targeted or things being unfair.
So Laura said something a moment ago that reminded me of something I wanted to ask, and thank you for that, Laura. When you said, well, federal prosecutors and state prosecutors are different, they don't, right? But there are people who have said, why is the Georgia case being brought? Because it looks a lot like the Washington, D.C. case that Jack Smith brought. And so you could make the argument, and I don't know what the answer is, could you, as U.S. Attorney for the Southern District of New York, call the DA somewhere and said, look, buddy, I'm the federal prosecutor, you're not, and I want my case to go. I don't want your case to go. And besides which, there's going to be someone at the 92NY that's going to ask a question about how it looks. And they're going to say it looks like it's, piling on.
Preet did that to the Attorney General of the United States. Forget about some state prosecutor.
Yes, exactly. That's why I'm asking you. Why didn't Jack Smith say to Fani Willis, you know what, just back off. It's my case.
I don't think he needed to. Sometimes it's the case, particularly in cases where there are cops who shoot unarmed people, and there's a civil rights case. The state brings a case, and sometimes the feds wait to see what happens with that case. Sometimes they bring a case simultaneously. My recollection is Derek Chauvin was charged federally even before we had a result in the state case. They're separate sovereigns, as lawyers say. That's for the CLE. They have different statutory elements. They have different missions, and they can go simultaneously. And that makes a ton of sense. And there's lots of stuff that's happening in the Georgia case that's not part of the Jack Smith case, and vice versa. So I don't know that he would necessarily have wanted to make such a call. I think a different question that has been debated a lot, and it's difficult to make this call as well, is why the Justice Department, at least to my knowledge, they didn't tell Congress, let us take the January 6th investigation first.
Instead of the select committee.
Correct. And again, there's a lot of debate about what they did.
Tell me why that's better, because it would have gone sooner?
Look, what we have been talking about here, and everyone's talking about all the time, it's not just the law, it's not just the legal penalties, it's not just the elements of the law, but the clock, right? And the clock is because of this election. And the clock matters because, as we've all discussed on other occasions, Donald Trump on the federal cases can just make them go away. He can potentially self-pardon. And we have these two legal memos that Neil referred to that have been unadjudicated, but they exist, to make all the cases go away. So because we have this election, because he decided to run, every case potentially goes away. So every day, week, month that was lost, given everyone's foreknowledge of this inflection point of the election, every bit of time that was lost is unfortunate. And if there had been a way to not lose that time, whether on the part of individual prosecutors in the states or the federal government and the Justice Department, it's too bad.
All right, last question, and it's from the audience, and we'll say goodnight to everyone. It says, it seems that the hush money case has the best chance to have a verdict before November. I think we've all said it's probably the only one that'll, but I think this questioner is thinking that, in fact, it will be a guilty verdict. I think that that's the perception. New York, as I said from the opening remarks, he's profoundly unpopular in New York City. You know, the odds are very high. So I think that this question is, does a guilty verdict move the needle for moderate Republicans and independent voters? Meaning, and this is a political question, but you're able to handle this. Do you think that the prejudice, you're not legal analysts, but I think you can do it. The prejudice, and this goes back to stuff that I've taught in law and literature, like things that Kafka and Dickens said about the legal system. The stain that you never get past, even if you're acquitted. Kafka's The Trial. It doesn't matter if you're acquitted. There are all sorts of acquittals. You're finished no matter what. This question, I think, speaks to the idea was just get a verdict of guilty, and then people just will run away. He will be stained forever. Or does Preet say, well, there's 80 million people who could care less, no matter what. And when Donald Trump, I jokingly said, I did have Jeb Bush here, and he was great, by the way. But you remember, was that the debate with Jeb Bush that he said, I could go out to Fifth Avenue right now and shoot someone dead, and my voters would vote for me, which sounded preposterous, but I think he was right, and he knew that. He knew it somehow, even then. So I'm wondering, this question from the audience is, do you think it would even matter to anyone who's on the fence?
I guess I have two quick reactions. One is the nature of this case in New York is reminding people of what they knew back in 2016. And I think for that reason, when you think about Access Hollywood, you think about other Stormy Daniels and other figures, Michael Cohen, who will be a part of this case, I think that might have less of an impact on moving the needle for some voters based on the nature of the case, that it's, in spite of what they knew about him, people still voted for him.
This is what they say baked in?
Access Hollywood happened before the election. People were aware of that, and so for that reason. The other issue, though, is this is one of the reasons where delay might backfire on Trump, because they're all still talking about these things going into the election, real heart of the season, when unlike the E. Jean Carroll civil suits, he's got to sit there for the criminal trials. And so one effect could be that he is removed from the campaign trail. He would do so for the period of time, probably 8 weeks long, for this trial to occur in Manhattan, if that's calculation is correct, and that could have a detrimental impact, in addition to having somebody who's now a convicted candidate. But I think the nature of the crime will dictate whether it moves the needle.
I think it will have an impact. I don't think that's a reason for these criminal prosecutions. I think that they should be brought because he's violated the rule of law. But, when you started, and I know it was a joke, but you said, oh, we don't have Republicans here. And I've been so privileged over the last 4 years to just meet a whole bunch of people who were diehard Republicans. I know there's at least one in the audience right now. There is. And who are aghast with what Donald Trump has done. And sure, the 25, 30% of people, I think, are, who are his diehard supporters, these convictions won't matter. But I do think that there's a really decent core of people who maybe like some of the Republican and Trump policies on tax or whatever, but when they see the facts and what this guy has done time and again, and it's all the same. I mean, each of these are different cases, but the same patterns of behavior emerge in each one. I do think it will matter to the American people.
I think the question that, I think, just to be clear, I think she or he was saying that when she said, or he said, moderate Republicans or independents, as if there's some people that would be leaning at this point toward Trump who would lean backwards if there was a guilty verdict.
So I think it would have a greater impact if one fact were different, and that is if the trial in New York were televised, right?
Oh, wow.
Because people's perceptions of the trial, no one's following the trial. Part of my job is to cover the trial. We can't get a pass to get into the trial, right? We're going to have to rely on other people talking about what happened during the day. I can't watch, I can't perceive it, and particularly the Trump supporters, that universe of people, because we're so balkanized in how we get our information, they're going to get it from the commentators at the end of the day who are going to say they swung and whiffed, they swung and missed again and again and again, and that will devalue even a unanimous jury verdict from, by the way, the very biased liberal New York jury pool. On the other hand, if you had a televised trial, in the same way you had, I thought perceptions moved markedly among moderates and maybe some Trump supporters also, because of the January 6th Select Committee, because it was public. And it was much harder to spin that stuff at the end of the day. So, well, it was a sham.
It was also prime time.
It's also prime time. People are smart. Juries are smart. And the general American public is the same as the jury pool, right? Generally speaking, the lay people who can make judgments about people's credibility, make judgments about the common sense arguments that are being made. And if they had the ability to watch every day that trial, which they would, I think you'd have a greater effect even than otherwise.
A definitive, though, primetime summation will be on CNN Laura Coates Live, 11 p.m. weeknights. Okay, check it out.
What are you doing on Monday night? All right, our night comes to an end. We love sharing this night with you folks at the 92Y. We're here all the time. Keep coming back to this place. It's a treasure. The cases of Donald Trump, Preet Bharara, Neil Katyal, Laura Coates.
Thank you.